death. And alternative punishment is life. That is as per the text. So till the Beckensen case, if judge is not giving death penalty, they should give reasons why death penalty is not given, why alternate punishment is given. But in Beckensen case, a new constitutional doctrine has been introduced into criminal justice. That is called rarest of rare cases. So in that case, it said that death penalty shall be given only in rarest of rare cases. So thereafter, after the Beckensen case, if the court has to give death penalty, they should give reasons why this particular case falls within the ambit of rarest of rare cases. 2 days back in Kerala, 15 accused were given death penalty in single case. All the 15 accused. You should read the judgment, how the judge could satisfy that it is falling within the rarest of rare cases. Appeal may come up with a different interpretation still. So here, another thing, Mittu versus State of Punjab. That is with respect to Section 303 of IPC. Suppose you, I'll ask you, suppose you kill a person. What is the offense punishable? 302. Punishment is either death or life imprisonment. Okay, you get acquitted. After 2 years, again you go and kill somebody. What is the offense? 302. Punishment is either death or life imprisonment. What is 303 says a person who is already undergoing life imprisonment, while undergoing the imprisonment commits another murder, he shall be punished with death. No choice, only death. Now, life imprisonment he completed. He comes out, again commits one more murder. What is offense? 302. Then again you get the chance of either death sentence or life imprisonment. So why this 303 attracts only death penalty? Because who enacted the law? Britishers. While undergoing life imprisonment means where the person is, the person will be in jail, isn't it? Who were the jailers at that time? Senior officers, Englishmen. So it was only to protect them. You have seen the movie Kala Pani. देखा किसी ने? हाँ. Okay, in that you will find Andaman Silver jails and all, how much torture they were inflicting on the people. And if anybody while undergoing they kills a person, that means attacks the jailers and all, they will be hanged to death. So this entire section 303 has been struck down as unconstitutional because there is no reasonable classification between a person undergoing life imprisonment and committing murder and another person committing murder, or this person also after undergoing imprisonment he commits murder. No, that classification is not reasonable. Again, this one. Navtej Singh Johar versus Union of India. What's the case? Section 377 IPC. Unnatural offences. So in this case, see, this is again a shift from the traditional concept of criminal jurisprudence. Unnatural offence, sex by between the same sex. It was considered to be sin at one point of time, thereafter crime at one point of time, and in this case, it said that carnal intercourse against the order of nature is not an offence if it is with consent. Okay, now again, new law is coming with a different stand on that. Then came the case of right to die. Right to speech is also right to silence. Right to travel is also right not to travel. Right to form association is also right not to form association, isn't it? So you have a right to freely move throughout the area of India, but nobody can compel you to move. You can say, "I will be here only." So if that is there, why not right to live? Also, be right to die. What do you think? The matter came up before the court seriously in one case, that is P. Ratnam versus Union of India in 1994. In that case, Supreme Court said that no, right to life is a very sacred life, right? It cannot be equated with the right to speech. You can right life is to be celebrated, should be respected. So nobody can be allowed to take their life even by himself. So right to die is not part of right to life. Okay. In Gyan Kaur versus State of Punjab. In that time they equated, in Gyan Kaur they overruled. Then what happened? 2006, Law Commission of India came with the reports on euthanasia. 2008, Law Commission again came out with the report that decriminalization of suicide. Why to make attempt to suicide? See, the thing is that you try to suicide. You are successful, no offense. If you are unsuccessful, again offense. So why that? Let it be decriminalized. So under the background of these two reports of Law Commission, another case, two cases came. One is Common Cause versus Union of India and Aruna Shanbag versus Union of India. I need not tell you the results. Right. Assisted passive euthanasia is allowed. So right to die is restrictfully allowed. Isn't it? Uh, then again, this I'll tell you before the rarest of rare cases. There's one case called Sushil Sharma versus Union of India, Delhi administration. That's called Tandoor murder case. Anybody knows the case? This Sushil Sharma, he killed his. The thing is that just like our Nanavati case, he suspected that his wife is having some extramarital relation. One day he came home, then he found she talking over phone to somebody and having drinks also. After seeing him, she disconnected. He sat the phone and redialed and found another person at the other end. Immediately he killed his wife. After killing, disposal of body becomes a challenge to all the offenders. He put it in a bony sack and brought it to the restaurant where his friend is working. Both of them cut it into different pieces and put it in the tandoor chula. Okay. So for their misfortune, a police constable was passing through. He could smell the tandoor this thing and he identified that it is human flesh. He was arrested. The trial court punished him with death. Now you tell me, you decide whether this falls under rarest of rare case or not. Now I'll tell you how far you understood this. Yes? Yes or no? No. Now you are acting not as a judge, you are acting through emotion. Are you so wife kaisa kiya, kata ho kiya? It is not a rarest of rare case. See, why he committed, see that's what I told you. You address the crime as a social institution. Understand the reason why he killed. It is a sudden provocation because he found her talking to her paramour. Right? So that is and another thing, he had no previous history of crime. He was not a criminal. On a fist of fury, he did sudden provocation. So it is not falling under the rarest of rare case. Don't go through emotions. Understand? Right. Again. Now I'll tell you another case. Bhagalpur blinding case. A series of that case is also not Khatri versus State of Bihar. A series of incidents happened in a jail, Bhagalpur Central Prison in Bihar during 1979 and 80. In that case, 36 under trial prisoners were blinded. How they are blinded? By the jail officials. They pour acid into their eyes and again they suspected that acid डालने के बाद भी इनका आंख है. Then they inserted some needles into the eyes and they were all blinded. And some people were released thereafter. They brought the matter to the court's notice. And it is so sensational case. And court said that blatant violation of Article 421. There is no excuse. Strict action was taken against the police officials. But in this case also, death penalty was not given. There are reasons. I am not in this forum. I cannot tell you that reasons are different. Okay. Yeah? So one more case. I will wind up with one more case. That is new case Puttaswamy versus Union of India. Right to privacy. See, right to privacy was recognized as part of fundamental right. It has a lot of relevance with respect to criminal law. When your data protection and everything is concerned, this will come in line with that. Similarly, Selvi's case with respect to data analysis, brain mapping, beeping test and all. So now people started asking, can the police take a breath test without the consent of the person? That is also not possible if you go strictly as per the law. Okay, so my idea was to share a few of my thoughts with respect to the constitutional provisions which safeguard our freedom, equality, and liberty, and how it impacts the criminal justice administration and how a new generation criminal jurisprudence have been developed in India. So, once again, I thank you all for bearing with me for such a long time. And, and also, congratulate the college administration for organizing such a very wonderful and relevant lecture. Thank you very much.
Thank you, sir, for sharing your knowledge and words of wisdom. It was really a great honor for all of us, and we got an opportunity to become a part of your lecture. Now, students, we have an opportunity that we could have an interaction between students and our resource person. So, if any questions, any doubts,
So thank you for being here. So my question is more of a suggestion for the upcoming lawyers. So I want to ask you like how when Dr. Babasaheb Ambedkar drafted the constitution, at that time our constitution did have socialism and secular law. So it was added and gifted to India, sorry, Bharat in 42nd amendment. So can you change the basic structure now?
The, see, basic structure itself, basic, basic structure itself, you're hearing, no? Basic structure itself is a matter of dispute. Because I will ask you one thing. The Constituent Assembly did not speak about basic structure. Basic structure was introduced by the court in Keshwanda and they said these are the basic structure, but not exhaustive. So in Minerva Mills case, they again expanded. So likewise, the court may in future expand or diminish basic structure also. And constitution again, it is said that constitution will be elastic through amendment so that it should cater the needs of the future generations and changes. I'll tell you with respect to secularism, do you think that India was less secular before 42nd Amendment? It was not. And do you think that it is now more secular after 42nd Amendment? That is, yeah, that is a matter of dispute again. Right. And now we have a lot of privatization. Still you have socialists in the preamble.
For example, if I am owning a company,
Hmm.
I don't want government to interfere. I pay my taxes, but I don't want any interference of the government.
Then it is not socialism.
This privatization,
Huh.
it was never a socialist country.
Yeah, so after socialists were included in what is the amendment, still you have privatization and bank nationalization and everything happened before the 42nd Amendment. So, see,
Sir, my question is, can we try?
yeah, we can try.
Can we try and
Yes.
do something from our constitution?
It is possible if you have a mandate. It is possible.
Any more questions?
If 370 can be removed, anything can be removed.
Sir, but Article 368 and Article 12 cannot change the law. As per the Article 12, it itself said that the union or state that they are making the such a regulation, such a law, not greater than to the our country. So how do we, if the amendment was the government has the amendment, government has the power, but this they cannot be the change because the constitution has given the changes related to the thing which are applicable, but it is not the heart of the constitution. Directly the change.
See, I will tell you. Yeah, see, the article what says that it should not infringe the fundamental right. So without affecting the fundamental right, that too basic structure, not the fundamental right.
Sir, preamble is also the part of the fundamental right. Yeah.
That is the most debatable question.
It's a more debatable question. So I will tell you, amendment. See,
There is a basic difference between amendment and
so you can, constitution can, parliament can amend any provision of the constitution. See, I will tell you, if you think in a wild sense, amendment means adding, deleting, altering, substituting, everything. Suppose the parliament comes with a thumping majority, 3/4 majority, they sit and take away Article 1, substitute with another thing. So like that, the entire constitution can be changed technically. But whether the government will do that, it is for the wisdom of the rulers to be taken. Otherwise, it's possible.
Everything is possible.
Anything is possible.
Thank you, sir. Now, as we have this completed Archana Parishad member of Board of Executive of Janardhan Vanashishtan Prasad Sanstha, I may request our principal ma'am, please rise to take Archana ma'am that has happened without gratitude for her presence in today's session. Thank you, ma'am. So I would like to invite our principal ma'am, Ms. Anil ma'am, to address the audience and share her thoughts about the end of this fifth day of this lecture.
Thank you, Samruddhi. Honorable Archana Thakur ma'am, respected Anil sir, my colleagues and my dear students. Looking at the theme of the lecture series, criminal justice system. Today, it is the fifth day wherein we have discussed about Indian Constitution and criminal jurisprudence. Thank you very much, sir, for connecting us to the Constitution and criminal jurisprudence. Because we all have jurisprudence in our subject. Almost all of you have already studied jurisprudence, many of you are going to study jurisprudence. Jurisprudence, here we have understood the term jurisprudence, stating that juris means law, prudentia is knowledge. So jurisprudence is knowledge of law. So to talk about criminal jurisprudence is the knowledge of the criminal law. Now, as Sir has started in the lecture stating that criminal law was there from the earlier. But here, talking about today's scenario, today's society, the criminal law is being framed in such a way that constitutional articles are being protected. So it is not just criminal law, it is a criminal law in a more constitutional way. So here we all have discussed about all the angles as to how the criminal justice system has evolved and developed from time to time, and today we have reached to this level. So Indian Constitution plays a very vital role in the criminal jurisprudence. So thank you very much, sir, for taking this topic and connecting us to the root of the law. Here I would like to take this opportunity to thank Sir, to acknowledge Sir and to tell you all that Sir has been my mentor for last 16 years. I have started my career with Sir. Sir was the first principal for me as the faculty. Sir has seen all ups and downs in my life. I would have not been here if Sir would have not been there in my life. Sir has always motivated me to be in this field. Sir has given me all those opportunities, be it MNL, be it SLD, be it Vivekananda Law College, everywhere, at every stage of my life. I have heard this from all the people those who have come in connect to the Sir. It's like there's not a single person who is connected to the Sir who will say that Sir has not played a role in his life. Sir is such a personality, ज्याच्या त्याच्या आयुष्यात येतं त्या माणसाचं आयुष्य एका वेगळ्या लेवलला ठेवून देतात. Sir, I'm so very fortunate and I would like to thank you from the bottom of my heart. Thank you very much for being there in my life. Here, in my, I was doing my masters. In my first masters, for some of the other technicalities and the difficulties, I could not score 55% in my LLM. And for that, LLM is the first criteria with 55%. So when the results were declared, I came to Sir, I was literally crying and I was like, my career in teaching is over now. And teaching is my passion. I wanted to come into teaching. And then I was already doing good in corporate law. I was like pretty well in that. But somewhere I wanted to do my career into it. So I was like doing that and I was like about to appear for the GATE exams and all. But then when I got to know that it is not coming to 55%, I came to Sir and I said, Sir, it's over now. It's not there. So I was like, wait, if you really wish to do it, you can do it again. He has taken a hold. He called the HOD of SNDT and it was the last admission. So I got admitted in SNDT in the month of September and I faced my exam in the month of October. So it was like the last decision, the last admission with the decision of Vice Chancellor that एक admission है हम लोगों को urgent level पे है हम लोगों को लेना है. It is all because of Sir and all that system he has changed. And then I cleared my NET, then I cleared my masters with good percentage. Before I could clear my masters, I had my NET, I had the teaching offer in my hand, and then I have done all these things. But if that day Sir would have not supported me, Sir would have accepted that, I would have not stand before this. So thank you very much, Sir, for shaping my life. So I wish you all the very best. आपकी भी लाइफ में सर जैसा कोई आए and आपका भी लाइफ ऐसे ही shape because it is like the life without guru is baseless. So thank you very much, sir. Archana madam, thank you again. Here for this lecture series, I feel so fortunate to be attached to this trust that for all the 6 days, each one of the member has made it sure that the lecture series is complete. Madam, with your presence, our lecture series complete because here it is something we are doing something and then we are getting an acknowledgement from the trust. So thank you very much, madam. तुमचा busy schedule वेळात काढून तुम्ही all the way इथून already madam 2 meetings सकाळी करून आलेले आहेत आणि मग आपली गडबड चालू होती. madam त्यातून सुद्धा madam has made it sure that to be here. Thank you very much, madam, for being here. Next thank you is to the students team. I appreciate a lot that all my students are doing so well that मी इथे आल्यापासून हा पहिला प्रोग्राम आहे जिथे मी सगळ्या टीचर्सना रिलॅक्स करते. Wherein all the teachers, they are just coming here, they are just giving instructions, and all my team, entire team, they are like, madam, tell me what is to be done, when the guests are coming, how they are coming, and they are completely taking charge of everything. So thank you very much, students, for doing this. Without your support, this program would not have been possible. Sir, ma'am, I would like to tell this to you both that for all the 6 days, this is the 5th day, पाचव्या दिवशी आपला पूर्ण मन असाच भरलेला आहे. So दुपारची वेळ आहे, त्याच्यामुळे मला थोडी शंका होती की तुम्ही 1 दिवस या, 2 दिवस या. तिसऱ्या दिवशी कुठेतरी असं होईल की मॅम रोज रोज ऑफिसमधून सुट्टी नाही मिळत, रोज रोज शक्य होत नाही. But you people have made it sure and तुम्ही हे सगळ्यांना आता दिलेला रिस्पेक्ट आहे. In these people have come. So thank you very much to the students, to the faculties and to the guests of honor. Thank you very much.
Thank you, ma'am, for all your appreciation. Now, as well as ending our program, I would like to invite Rashtripan to the fourth year BLS to express our gratitude and deliver a vote of thanks.
Thank you, Samruddhi. Very good afternoon to one and all present here. I, Ms. Rajdeepa Anuraj Marvi, student of 4th year BLS LLB. On behalf of Janardhan Bhagat Shikshan Prasarak Sansthan, Bhagubai Sangu Thakur College of Law, and the entire fraternity of the institution, as we bring the curtains down on the 5th day of the captivating lecture series, I extend my sincerest gratitude to the Janardhan Bhagat Shikshan Prasarak Sansthan to give us the opportunity to make today's event a resounding success. As we all know that gratitude is the language of the heart. To show appreciation towards a person, but these words would be less for our today's guest of Honorable Ms. Archana Paresh Thakur ma'am for kindly gracing the events with their presence. On behalf of my institution, I extend my heartfelt appreciation to Chief Guest Honorable Dr. Anil Variath sir, who has spared his time from his busy schedule to grace the event. Today, we had an opportunity to hear your thoughtful session, sir. And this insight gained during this session will serve as a beacon for future endeavors. A special mention to our respected principal, Mrs. Sanvi Deshmukh ma'am, for being the catalyst that simulated to do our best for today's program. An event like this cannot happen overnight. The wheel started rolling weeks ago. It requires planning and bird's eye for details. With a deep sense of appreciation, we thank our all beloved and respectful professors and all our non-teaching staff. I would also like to thank the people who work behind the scenes because of their meticulous efforts made this event possible and successful. Last but not least, a big thank you to each of one for the discipline and a good listener. Thank you so much.
Thank you, Rajdeepa. Before concluding this session, I would request you all to please stand up for the national.